Good morning. This is the appointed time. We have a quorum. So, welcome members to the meeting of the panel on financial affairs. First item, information paper issued since the last meeting. Since the regular meeting in June, the panel has received one information paper. You will find details in the agenda. Next items for discussion at the next meeting. The next meeting, regular meeting in October, is scheduled the 5th of October, a Monday from 9:30 p.m. onwards. The administration has proposed to discuss two items. First, work of the Financial Services Development Council, and second, preferential policy packages to attract industries and investments, tax incentives. So do we agree to the two items? I see that there is agreement. The next item is enhancement of stamp duty relief for intra-group transfers of enterprise group. I see that the administration has come in. Members, if you want to speak, please press the request to speak button. And let me welcome the administration to our meeting. We are joined by the FSTB's team and the IRD's team. So Mr. Andrew Lai will give a presentation, and please be succinct so that there is more time for members to ask questions. Thank you, Chair. I'll be very quick. This is a rather straightforward recommendation, and that is we plan to introduce stamp duty relief as proposed in Budget 2026-27. Now, we want to relax the criteria for stamp duty relief in relation to intra-group transfer of enterprise groups so as to create an even more favorable environment for internal restructuring of groups. Now, under the current stamp duty ordinance, to effect transfer of immovable property, there is or stocks, it is generally subject to stamp duty. There is also a mechanism to grant stamp duty relief for transfer of immovable property or stamp duty within the group. This is called intra-group relief. We will introduce the association test because currently, if the body corporate is a beneficial owner of not less than 90% of the shared capital of the other, or the third party is the same of not less than 90% of the shared capital of the two bodies, then they would meet the association test criteria. Now, in the business world, there are new modus operandi, and that we need to catch up with the times. So we'd like to further enhance the stamp duty relief arrangement for intergroup transfer. We will work on two fronts. First, in the past, we only considered issued shared capital as the threshold. We'll now expand this scope, and that is we look at the beneficial interest and also the voting capital. In other words, for limited liability partnership as well as company limited by guarantee without shared capital, these are new types of incorporated entities, and they will benefit from the proposed stamp duty relief. As for the shareholding threshold, we will lower that from 90% to 75%. Through introducing these two enhanced measures, we'll be able to further improve the business environment for entities, and at the same time, we will make sure that our stamp duty mechanism remains reasonable and competitive. We will keep the existing criteria threshold so as to combat abuse. That means for intra-group relief that have been granted because of transfer of immovable property to an associated company, and if the property or shares are then sold to a third party within 2 years, then the relief is deemed to be withdrawn. so as to introduce anti-abuse provisions. We've made reference to the views of the business sector and the accountancy sector, and with members' support, we plan to introduce the amendment bill to LegCo in October this year. Subject to passage, the relaxed criteria will take retrospective effect from the 25th of February 2026, and that is the date of delivery of the budget, and that instrument submitted on or after that date will benefit from the proposed relief. I'll be happy to take questions from members. Let me read out the names of members waiting to speak. Mr. Johnny Ng, Deputy Chair Rock Chan, Nick Chan, Albert Zhang, Carmen Kan, Ronald Chan, Michael Ngai, Webster Ng, Ken Lee, and Alan Chan. Let's start with Mr. Johnny Ng. Thank you, Chair. I'm sorry. Let me remind members first, 3 minutes questions and answers. We have 4 items for discussion today, so I'll just give each member 3 minutes. In principle, I support this legislative proposal. Here is my concern. We need to create a favorable business environment. We want to prevent loss of tax revenue. Now, have you conducted any assessment as to how many multinational corporations will be willing to re-domicile in Hong Kong, and how far will it help in promoting trading? And that this proposal will take retrospective effect from the 25th of February. That is, it will date back to a few months before now. And have you conducted any or sought advice from the IRD as to how long it would take for the relief to be granted? P.S. Thank you, Mr. Zhang, for your support. Now, about this relaxed criteria and the assessment on our competitiveness, it's rather difficult to conduct a quantitative analysis. Now, following the existing practice, we adopt an issued share capital approach, and you only benefit from the stamp duty relief if the corporate is a beneficial owner of at least 90% of the shared capital. After relaxing the criteria, more companies will benefit from it. In fact, if we take a look at the past 5 years, there were close to 10 such cases. And that if we're able to lower the threshold from 90% to 75%, at least 2 or 3 such transactions will benefit from the arrangement. Now, some companies know that they are not eligible. For example, for new corporate structure like limited partnership by guarantee, or those without share capital, they are not eligible under the existing structure, but they will get registration in Hong Kong anyway, and that they will benefit from the new arrangement. About the the effective date, it will date back to the 25th of February this year. Now, the sector is aware of our proposal. We just need to go through the steps to amend the law. So they are ready to apply for the grant of the relief, and that upon passage of the law, they will be informed by the IRC, and that if they meet the criteria, they will be granted the relief. Otherwise, they will be charged with stamp duty as usual. As for transaction of immovable properties or shares by these corporations, they will not be affected. It's just a matter of how much, in terms of stamp duty, they have to pay. Deputy Chair, Mr. Rock Chan. Thank you, Chair. I support lowering the threshold to 75%. According to the paper, in paragraph 11, the administration will keep the anti-abuse provisions, and there will also be corresponding amendments. Now, my concern is whether there will be a surge of abuse cases after lowering the threshold. Will there be sufficient safeguard offered by the anti-abuse provisions? How will you take forward the amendments? The next question is this. The government last month announced an action plan on the promotion of corporate treasury centers in Hong Kong. Now, I think lowering the threshold and offering stamp duty relief will attract enterprises to set up CTCs in Hong Kong. So my question is whether the government will mount publicity using all these preferential measures as a whole package so as to attract more enterprises to set up CTCs in Hong Kong. P.S. Thank you, Chair. Thank you, Deputy Chair, Mr. Wok Chan, for your support about the anti-abuse provisions. I will give the floor to the IRC to further elucidate. On promotion and publicity, rest assured, the FSTB will work with Invest Hong Kong and also Oasis. We will step up publicity of the enhancement measures. We will also explain the whole package of other financial preferential treatments to the interested parties so as to attract businesses. Mr. Chan, Commissioner, let me explain the anti-abuse provisions. It works on two fronts. First, this is not, if it's not transfer within the group, then basically this will not be eligible for stamp duty. In other words, if the asset is transferred to a third party outside of the group, then this is abuse, and this is how the anti-abuse provisions come into effect. Let me explain. In terms of transfer, the consideration will have to be paid by the unit receiving the transfer, and that's the transferee, and it's clearly provided in the provision. The second point is that the transferee will not leave the group upon receiving the assets. And we'd like to take it further, and that is we have a withdrawal mechanism. That is, after completion of the transfer of assets, if the subsidiary then or the asset then leaves the group, then we will withdraw the relief granted. Mr. Nick Chan. Chairman, I support granting stamp duty relief for intra-group transfers of enterprise groups, and that the threshold should be lowered from 90% to 75%. I think that this can help lower the cost for enterprises to expand or restructure their businesses. According to the administration, it's hard to quantify the economic benefits. But my question is this: will there be specific indicators to assess the effectiveness of the measure? For example, in terms of the number of enterprises undergoing restructuring, or will you gauge the increase in the inflow of capital and investment? Thank you, Chair. Thank you, Mr. Nick Chan, for your support. Like the IRD just explained, we will monitor the effectiveness of the new arrangement. For example, we will record the types of companies benefiting from the stamp duty relief after lowering the threshold to 75%. We're going to collect statistics and report to members in a timely manner. However, I'd like members to understand that when it comes to restructuring within the group, there are many things affecting the decision-making process apart from the tax policy. The group may have regard to their own circumstances. Say, for example, if the group is to be listed or if there are other development plans, there may be these may be factors affecting restructuring. Next.
Mr. Albert Chung. Thank you, Chair. I support the enhanced arrangements. The relevant ordinance has not been amended since 1981. It does not keep abreast with the times. And I am glad that the administration has referred to the practices in other jurisdictions, including the UK and Singapore. I think that is a pragmatic approach. I note in the UK there is a court case on ordinary share capital. Apparently, there are some maneuvers that would cause a threshold to reach 75%. In the end, they should not be entitled to tax concessions. And I also note that in some cases that have weighted voting rights, and the founders issued some shares, and in the end, the voting right percentage dropped to 40%, and they did not receive an exemption from the authority in Singapore. Would you consider referring to more practices in other jurisdictions? Mr. Albert Trong, I think you should focus in particular on stamp duty relief for intra-group transfers. You need to make sure what you quoted are relevant. I'm just asking if we can refer to examples overseas to prevent potential disputes. Thank you. Well, regarding what Mr. Albert Trong said, when there are intra-group preference shares or weighted voting rights arrangements or structures, what is going to happen? I'll let Mr. Benjamin Chen from the Inland Revenue Department provide a more detailed answer. Thank you, Chair. Basically, we have only made 2 amendments. One, we have made enhancements in relation to the use of the requirement based on share capital. So say a company or an entity, or what we call a body corporate, how much interest is there in another entity. We would used to only refer to share capital, but now we can look at, say, profits shared. We will make clear of the specifics in the proposals. For some companies, they do not have share capital issued, or they do not have specifically an interest. So we would use the voting right threshold, and as long as it meets the 75% threshold, it will be covered. We want to cover more of such entities, basically, for the stamp duty relief. The member quoted some court cases in the UK and other places. We will review the cases. It really hinges on what the definition is. We also have a Court of Final Appeal case where it says for intra-group transfer, relevant arrangements can be considered when considering whether the threshold is met. But we will make sure that our definition meets our policy intent. Thank you. Ms. Carmen Khan. Thank you, Chair. I support the changes made so as to widen the scope of stamp duty relief. As the administration's representative said, we also have limited partnerships in Hong Kong. And I note John Williams and Sons LLP case in the UK. The court also said the relief should be extended to those entities that do not have an issued share capital, including limited partnerships. I hope that the administration will have regard to this case before making our proposals. In fact, Singapore already has made relevant changes in 2008. We are definitely lagging behind. I also note in the paper it said in paragraph 10, in Singapore, they have requirements on a specified entity having 75% or more voting capital and I emphasize that, 50% or more voting power in another specified entity. So I want to ask if our requirements are lesser than those of Singapore. We have some sort of anti-abuse provisions where within 2 years there should not be further transfers to other entities. How do we compare to other jurisdictions in relation to the specific arrangements? Thank you. Mr. Benjamin Chen. Thank you. Let me first respond to the question on Singapore's practice. Regarding equity interests and voting right, they have different thresholds. So for voting capital, it's 75%. For voting power, it's 50%. This makes things more complex in operation. We note in the UK and Ireland, they do not have such requirements. So our regime is simpler. It would cover more entities. It is basically a simpler and more facilitating approach. So with the 2-year condition in the UK and Singapore, they also make use of the same time period. Thank you. Mr. Chan Chunying. Thank you, Chair. I support the relevant measures, but I have 2 technical questions that I want to ask. We have talked about how we would lower the threshold from 90% to 75%, but the administration did not mention for, say, a case where property is transferred to a subsidiary, and with that, we would still have, even with a wholly owned subsidiary, with there being some specific structures, it would lower the percentage, but it would still reach 75%. Would it cover? Will they still be entitled to the stamp duty relief? I want to ask, you have a 2-year condition, but if they make a transfer immediately after 2 years, they may still benefit. So would you have some sort of tiered penalty so that they won't be earning some sort of time value from that? I will ask Mr. Benjamin Chen to respond to the members' questions. Thank you. Chair, if one holds an entity indirectly of 75% interest, they would still benefit from the stamp duty relief. We would actually make clear of that in law. And in fact, for the anti-abuse provisions, if there are any specific arrangements where the entity would leave the group after obtaining specific assets, they would not be entitled to the relief. So basically, if one already has that intention when making the trade, that it will leave the group eventually, one is not entitled to the relief. It may happen 2 years later, but if one does not have such intention and that happens within the 2-year period, we would just recover the stamp duty to be charged. That's the difference. So, as I said earlier, if the subsidiary is already planning to leave the group, that relevant transfer will not be entitled to relief. Thank you. Professor Michael I. Thank you, Chair. Lowering the threshold from 90% to 75%, I agree that should enhance Hong Kong's status as an international investment and commercial hub. What Ms. Carmen Khan and Mr. Chen Chen-ying said are exactly my concerns. The administration said they refer to practices in the UK and Singapore. And I would like to actually say in the UK, they have a period for pursuing recovery being more than 2 years. Why can't we have a longer period? Is 2 years enough? If people abuse the loophole, how can we make clear what the penalties will be? Thank you. Permanent Secretary. Thank you, member, for your support. Regarding the validity period of the anti-abuse provisions, we have all along adopted the period of 2 years. Even with the enhancements, we do not plan on lengthening the period. It's because we are trying to strike a balance. In the commercial world, we understand that companies may make certain decisions at different times. We don't want to affect companies who are undergoing normal restructuring operations. As for penalties, I'll see if Mr. Benjamin Chen has anything to add. Thank you, Chair. As I responded to Mr. Chen, our approach is actually in line with that of the UK. If an asset is transferred to a transferee and the transferee eventually leaves the group will not be entitled to stamp duty relief. This is the same in the UK. We have actually one more arrangement where we would have a clawback mechanism. So our mechanism is actually quite stringent in terms of preventing abuse. As for penalties, for a group to apply for stamp duty relief for intra-group transfers, they have to provide much information to us. If they provide incorrect information, as they have to make a declaration, a statutory declaration. If they declare there is no intention of leaving the group of an entity, and we find out that to not be true, it would mean for a breach of 2 offenses, one being a stamp duty ordinance in providing incorrect information, the other is lying under the statutory declaration. Thank you. Dr. Webster, thank you. I definitely support lowering the threshold from 90% to 75% because that will definitely help attract investment. We had different members ask and compare the practices of different tax jurisdictions. I actually have a question on 75% voting right requirement. Every year, there may be some personnel changes. Is it some sort of loophole for abuse so that with change of people, they may be able to benefit from stamp duty relief? I note in paragraph 13, the administration said they could not estimate the decrease in government revenue. I believe we will be able to attract more businesses that will help increased stamp duty, but then of course there's also a decrease in tax revenue. Do we have some information on past 3 years figures so that we can make some analyses? Thank you.
P.S. Thank you, Mr. Webster Ng, for the questions. We will collate information after the meeting and provide a written response to the panel. Now, about the voting right in the execution aspect, I will give the floor to the Commissioner. The member has made a very good point in relation to the voting power. There are always changes within the company. However, do they lead to abuse of the stamp duty relief arrangement? We will need to consider the arrangement as a whole. That is, whether there is a substantive need for the company to change the voting power, or whether the company is manipulating the voting power for the purpose of getting stamp duty relief. In the latter case, and if the arrangement is not in anyone's business interest at all, then the anti-tax evasion or anti-abuse provisions and principles apply. And that means we can make use of these provisions to combat, say, tax evasion. This is something that my bureau and the IRD will closely monitor, and there are ways to tackle the abuse. I think a number of members have asked questions in relation to the second part of the question, and that is tax implications. So perhaps when you give a written response after the meeting, do provide the details. This is a concern of many members. Mr. Kenley, I support the proposed enhancement of stamp duty relief for intra-group transfers of enterprise groups. I'd like to pick up on the members' previous questions, and that there will be a drop in tax revenue and it's hard to conduct a quantified analysis. Now, that's the case for a drop in tax revenue. What about benefits? Can we quantify the increased benefits? Will there be KPIs? Now, about the retrospective effect of the enhancement measure, will there be grandfathering arrangements on top of introducing this retrospective effective date of the 25th of February? Retrospective effect. Our plan is to have the arrangement take effect starting from the 25th of February, that is the delivery of the budget. And for instruments of transfer effected on or after that date, they will benefit from the stamp duty stamp duty relief. According to the new mechanism, the relaxed criteria will be adopted in assessing the instruments. To answer the first question, let me give the floor to the Commissioner. Yes, Commissioner. Thank you, Chair. Thank you, Member, for the questions. As the PS already responded, be it a drop in tax revenue or increase in benefits, these are rather difficult to quantify directly. After lowering the threshold, we believe that there will be more transactions involving intra-group transfer of assets benefiting from the enhanced arrangement. But in fact, when it comes to intra-group transfers, the trend is rather stable. That is, the groups will have regard to the business environment, the market situation, especially relating to the property market, before making this decision. Now, even if we lower the threshold, we may not instantly see the result. There may not be a surge in the number of applications. I mean, this may not be apparent, but we will keep things in view and see what happens. It's quite difficult to quantify the outcome. Mr. Alan Chan. Thank you, Chair. I support the enhancement of stamp duty relief for intra-group transfers of enterprise groups for two reasons. First, for company limited by guarantee without share capital, this is a new structure that allows voting power to be kept in place. Now, since the introduction of the new law in 1981, there have been many corporations under the limited by guarantee model. This is also the approach taken by many family funds. And there are also VCs, venture capital funds. Many tech firms have adopted this new structure as well. So relaxing the criteria will be very conducive to promoting the family funds and increasing investment in tech. The second point is the threshold will be lowered from 90% to 75%. We're talking about a change from almost total ownership or total control to substantive ownership. Now, in fact, if you have 5%, you can even alter the articles of association just by reaching the 75% threshold and not 90%. So this may make us less competitive comparing to UK and Singapore. Our competitiveness cannot stand out. So I have two questions. Now, will weighted voting rights be included? That is for 18C and 18A companies, will they be included? The second point is that we should not just keep up with other countries. We should take the lead. So be it weighted voting rights or other aspects, will we do more so as to attract more companies to set up CTCs in Hong Kong? P.S. Thank you, Chair. I fully agree with Mr. Alan Chan that we need to keep up with the times and we need to have regard to all the new things happening in the business world and see what can be done to further enhance the tax regime. As for weighted voting rights, I will give the floor to the Commissioner to give you more details. Thank you, Chair. Thank you, Member, for the questions about this practice in Singapore. There are two requirements. First, 75% of more voting capital. Second, 50% of voting power. As for our arrangement, we will bring these two on a par. That is, either the voting capital or voting rights or voting power should reach 75% in order to be eligible for the relief. So I'd say that we adopt an even more relaxed approach comparing to Singapore. Now, will we consider adopting a more relaxed approach? I think he just answered. He said that our criteria are more relaxed. Next, Mr. Jonathan Lampert. Thank you, Chair. The Hong Kong GCC supports this proposal. This will bring convenience to corporations and groups of different structure doing business here. I think it's a good deed. I have a number of questions already asked by members. I'm glad to know that when it comes to the drop in tax revenue due to the relaxation of criteria, I hope the administration will give us some figures so as to gauge the impact. The second point is about the number of enterprises that will benefit from the proposed arrangement after undergoing restructuring. And I emphasize that this is about local enterprises. P.S. Thank you, Chair. Thank you, Mr. Lampert, for his concern on the effectiveness of the policy. From our perspective, by relaxing the threshold, we will create a better and more favorable business environment for corporate restructuring. And this is definitely beneficial to them. As for financial implications or economic benefits, we will need to check information and make a report later. What is more important is the way forward. After introducing the new arrangement, we will review the situation sometime down the road, and then we will be able to conduct an analysis and report to members. But I think the most straightforward interpretation is that for companies at the moment not eligible for stamp duty relief, they will benefit from the enhancement. So this is a breakthrough. Next, Mr. Holden Chow. I wanted to ask a number of questions, but they have already been asked by other members. So I'd like to say that I think this will be useful in attracting businesses undergoing restructuring here. Like Mr. Lampert said, I'd like to know how many local enterprises will benefit from it. Let's say if the government has the statistics in hand, please publish them, because some corporations might want to undergo restructuring. They might not benefit from the current practice, but upon introduction of the enhancement measure, they will benefit from it. So present the information by infographics. This can help us understand better, so that you can have our support. The key is when you explain to the local community, you need to be able to give them the key points, because indeed the tax revenue will drop, but who will benefit from the arrangement? How many more enterprises will benefit from it? I think you should prepare infographics and elucidate the situation. Right, anything to add in terms of promotion, publicity, and infographics? Thank you, Chair. We agree with Mr. Holden Chow. We're going to collate information and report to members, and we'll definitely take on board Mr. Chow's and other members' views on promotion and publicity. Right, next, Dr. Sunny Tan. I support enhancement of the stamp duty relief for intra-group transfers. This is an active measure to support Hong Kong's status as an international financial center and an international trading center. Corporations restructure their businesses and assets because of a number of reasons. For example, they may wish to improve the rate of return in their books, or they may wish to get listed. Say if you apply for 25% of your shares to be listed, then you can hit the 75% threshold, and then with green shoe and other arrangements, secondary offering, for example, you can then further increase the size of assets within 2 years. I'd like to know how this will be dealt with. I'll give the floor to the Commissioner. Thank you, Chair. Thank you, Dr. Tan, for the questions. About intra-group transfers, let me explain what we've come across. Usually, they involve internal restructuring of the company's businesses. There is a need for the subsidiary companies of the group to be held from one entity to another within the group, that is from A to B, for example, and there may be transfer of immovable property involved. This may due to the company's plan to develop a property, for example. But when it comes to listing matters, like Dr. Tan said, we need to be very careful, because upon restructuring the business, in the end, this subsidiary company may be getting listed, and that the majority of voting rights may leave the group altogether, perhaps in a situation of a spin-off. In such circumstances, they do not qualify for the relaxed stamp duty relief arrangement, because at the outset, I already explained that after effecting the transfer, the subsidiary should remain in the group, and that is 75% of the issued share capital should remain within the group. However, we have come across cases before, that is, say, after restructuring, 50 or at least 40% of the shared capital have been sold to an outsider, and that makes the company ineligible.
I would draw the line here. We have myself wanting to speak for the first round, and we have another member wanting to speak for the second round. I would draw the line after that. I have some questions. The administration has communicated with us adequately before this meeting about this subject. For tax relief relating to intra-group transfers, it may affect many different enterprises. I am most concerned about gold and silver traders. There are multiple members in the associations. We want to set up a gold exchange in Hong Kong. And we're not talking about some groups directly holding properties. I just hope that the administration will provide support gold traders so that they can comply with relevant laws. Let me also declare an interest here. The organization I serve is also a gold trader and will be part of the gold exchange. Thank you. Permanent Secretary, thank you. We understand where the chairman is coming from. We have a unit, the unit being body corporates. So only body corporates will be eligible for stamp duty relief. For gold and silver traders, they are registered as societies. So with that, they cannot directly control assets. So they unfortunately will not be entitled to stamp duty relief even with the enhanced arrangements. But if the Chinese gold and silver exchange have any questions, the company's registry can most definitely communicate with them. We of course want to facilitate Hong Kong's development as a gold exchange center. Thank you. Mr. Nick Chen, I'll assign a 2-minute time limit for your second round. Thank you, Chair. Many organizations will hold important assets through companies. So say if we have transfer of an asset from company A to company B within a group, will there be any premises on top of the requirements? Say, would you ask for a share transfer agreement to be signed beforehand? Or the associate entity being in the group for more than 12 months? How will we deal with these specific scenarios with the enhanced arrangements? Mr. Benjamin Chen. Thank you, Chair. Thank you, Mr. Chen, for the questions. Before amendments are made, we already asked for the transferor and transferee, the two companies, to have a 90% threshold under the association test, and we look at the share capital for that. We do not ask for this to be met for 12 months before the trade, because what is important is during the trade and afterwards they can maintain that. We have encountered cases before where there are some groups trying to meet the 90% threshold, and what they did was they would issue some share capital that do not have voting rights, and we have dealt with them with anti-abuse provisions, and this approach is confirmed by the Court of Final Appeal. Thank you. Thank you for the administration's representative's explanation. Now, I want to ask if members have any specific comments on the administration's plan to submit the proposals to the LegCo in October this year. If not, thank you. We will move on to the next agenda item. Enhancing the real estate investment trust regime and the market conduct regime for listed collective investment schemes. I will also invite representatives from the administration to come inside the conference room. Members may press the request to speak button if they wish to speak.
好，我哋歡迎財經事務及
Welcome, representatives from the FSTB as well as the SFC. When you're ready, I will ask Mr. Joseph Chen to give a presentation. To save more time for members to ask questions, I will ask the Undersecretary to be brief. When you're ready, please, Undersecretary. Thank you, Chair. Good morning, Chair and members. Today I'm here with team members from the SFC to brief members on the legislative proposals to enhance the REIT regime and the market conduct regime for listed collective investment schemes. The National 15th Five-Year Plan supports strengthening Hong Kong's functions as an international asset and wealth management center. And according to SFC's latest survey figures, in Hong Kong, we are managing assets in 2025 increased by 20%, and the net fund inflows has nearly doubled to $2.1 trillion Hong Kong dollars. We have surpassed Switzerland in becoming the largest asset and wealth management center. Between 2025 and 2030, we have an annual growth rate of 9% in the management of cross-boundary assets. We have 11 REITs listed in Hong Kong. The capitalization is about 149.6 Hong Kong dollars. Since 2005, when the first REIT was listed, we have seen close to six-fold in growth. The government has adopted different measures to enhance Hong Kong's competitiveness as an international asset management center. On 24th of June, we have introduced a bill to LegCo for enhancing the preferential tax regimes for funds, single-family offices, and carried interest. We are also trying to foster an ecosystem. We have set up a dedicated team for family offices. We want to facilitate exchanges among family offices. We also held investment promotion activities in different parts of the world. We want to make sure to also provide comprehensive investor protection to investors, which is why we have the following proposals to support the sustainable development of the industry. Right now, in accordance with Chapter 622, there is a statutory mechanism to effect restructuring by arrangement or compromise by a company. But because REITs are incorporated as trusts, these arrangements are not applicable to them. So the SFC suggests introducing similar arrangements under Chapter 571, the Securities and Futures Ordinance for REITs. And the statutory mechanism will be similar to that under the company's ordinance, including the major requirements, thresholds. We want to provide to REITs a clearer restructuring and privatization mechanism. While we do refer to the provisions under the company's ordinance, we will make specific changes to make them more suitable for REITs and to facilitate their development. We believe the proposed statutory mechanism will aid the development of the REIT market and increase liquidity. The Securities and Futures Ordinance also has a market misconduct or conduct regime. So we have specific misconducts as well as disclosure of information and the relevant penalties. The specific rules are more focused on listed companies as we see greater prevalence of listed collective investment schemes. For market misconduct and disclosure of information as well as disclosure of interests, we plan to make sure to specify they cover also collective investment schemes. And we have in some major markets that practice the same approach. And with ETFs and REITs, the listed collective investment schemes are already subject to regulation by the SFC through their different codes, and there are specific provisions on disclosure, compliance, etc. We want to make clear the market conduct regime under the Securities and Futures Ordinance be made specifically applicable also to listed collective investment schemes to enhance integrity of the market and for the benefit of long-term development of the fund industry. Between March and May 2024, the SFC conducted a public consultation and there was general support for the proposals. We believe the relevant arrangements will provide clearer guidance and enhance investor protection, and that will provide a comprehensive governance framework for relevant schemes. We will soon submit to the LegCo the proposals. We hope to have members' support then. My team and I are more than willing to answer members' questions. That's it for my report. Thank you. Thank you. I'll assign a 3-minute time limit because time is relatively tight. We have quite a number of agenda items. I will also ask the administration's representatives and members to be succinct. Let me read out the order in which members are going to speak. Ms. Carmen Khan, Mr. Rock Chen, Mr. Chen Chen-ying, Dr. Johnny Ng, Mr. Andrew Yao, Mr. Albert Chung, Mr. Holden Chow, and Mr. Nick Chen. Ms. Carmen Khan.
Thank you, Chair. Paragraph 5 of the paper refers to 11 REITs being listed in Hong Kong as of the end of May at a IPO size of $150 billion. In fact, before that, for companies without the withdrawal mechanism, it is far less than ideal because they will need to settle in total before withdrawing from the market. So have you talked to the sector about this enhancement mechanism and about the opportunities for REITs? Now, for other jurisdictions, how do we fare in terms of whether we are providing convenience, or whether the market accepts the proposal? Thank you, member, for the question. In the past few years, the government has rolled out different measures to support the development of REITs. For example, we have offered stamp duty waiver for transfer of REIT units, and we've also enhanced the arrangements for the funds recognition procedures, issuance requirements. Now, indeed, the size of REITs IPO have increased by 20% compared to 2024. It stood at 149.6 billion as of the end of May. And we believe that there are still other potential REITs that wish to be listed in Hong Kong. We believe that the arrangement will further enhance our competitiveness. The SFC has been communicating with the sector. Perhaps they can share with you the feedback and responses received. About how we fare comparing to other jurisdictions, I'd say that we have similar mechanisms comparing to places nearby, such as Singapore, Australia. They have the procedures for trust schemes. We also adopt a similar procedure. On the whole, the sector provides strong support to our arrangements. That is, in fact, the procedures are similar. For REITs, the unit holders will need to take part in a meeting, and likewise, there will be advance notice issued to the unit holders. There will be detailed explanation of the arrangements for the voting process to be taken place, and the majority vote is needed, and the majority vote threshold is 75%, and that's similar to the Singapore and Australian arrangement, subject to courts sanctioning as well. I will give the floor to the SFC about consultation of the market. Thank you, Ms. Khan, for the question. Like the Commissioner mentioned, the SFC has been in close liaison with the sector. Now, we understand that for REITs, there are buyback activities as well. They have also begun acquiring different types of assets, such as student dormitories. As pointed out by the Deputy Commissioner, we see potential investors, and they have approached SFC in getting understanding of the rules. We see potential new assets, including warehouses as well as facilities for the healthcare sector. Mr. Rothschild, I have a point of clarification. Now, the proposal itself is entirely all right. We want to provide facilitation for REITs to effect restructuring by arrangement or compromise. But my question is that for REITs undergoing M&A or buyback, an independent financial consultant will have to be appointed as required by the SFC to provide expert advice to minority shareholders. I need to clarify that. And also about our comparison with Singapore and Australia. And you have explained the situation. What about the mainland? In terms of consistency or harmonization of the laws of two places. The third point is this. Through passage of the bill, there will be a new arrangement for REITs. The REITs nowadays acquire different types of assets, such as residential properties, student dormitories, offices, data centers, etc. But the trend is mostly about the data centers, logistics parks. Will there be other preferential measures to attract more REITs to come listed in Hong Kong? Thank you, Chair. About the first question about financial consultant as required by the SFC, and also our comparison with the mainland arrangement. I'll give the floor to the SFC in a moment. Let me take the third question first. For potential applicants who wish to issue REITs in Hong Kong, they consider new asset classes as well. About the acquisition activities in Hong Kong, apart from traditional properties, they also consider some alternatives such as student dormitories. Now, as for other interested applicants, they've talked about buying, say, for example, data centers and warehouses, healthcare related properties, and we've been talking to them as well. We'll continue to mount publicity and promotion. I'll give the floor to the SFC to take the first and second question. Who would take the question, please, Ms. Chan? Now, we mostly follow the mechanism under the company's ordinance when it comes to the IFA question. For acquisition and merger and buyback, apart from the existing mechanism under the company's ordinance, they will also need to observe the takeover rules under the SFC, and that the SFC does require an independent financial consultant to be appointed to provide advice to minority shareholders. What about the point about comparing to the mainland, Ms. Chair? In the mainland, REITs is something new to them. They've only allowed REITs to raise funds through public channels in recent years. According to their mechanism, there are no specific provisions relating to restructuring by agreement or compromise. That is compulsory buyback. I think this has to do with the development history and the market development of the two places. But we do have frequent exchanges, and we will further exchange ideas on different matters, especially after we've completed the legislative process. We'll be informed of the latest development on the other side as well. Mr. Ronald Chan. Thank you, Chairman. I support the enhancement of the two regimes. Now, about the first question, after acquiring 90%, the majority can then apply for compulsory buyback, but according to the paper, minority unit holders can apply to the court for an injunction of specific performance to stop the buyback, but there is no time limit mentioned here, as well as the percentage threshold for minority shareholders. The second point is that in relation to CIS regime, now, especially for market misconduct provisions, they will come into effect right after Gazetto. This is reasonable. On disclosure, it is mentioned that you give sufficient time for the sector to adapt to the new arrangement. That is, an effective date of operation will be appointed later. Is there any idea roughly when this will happen? Is it like 6 months or a year down the road? Now, two questions. I will give the floor to my colleagues, but let me give you an overview briefly in the interest of time about the mainland. I'd like to emphasize 3 points. Listed REITs in Hong Kong are able to buy properties in the mainland. This is permissible. Second, the company's ordinance in Hong Kong and the common law system in Hong Kong form a different basis comparing to the basis in the mainland. So when it comes to actual operation, we cannot make a direct comparison. The third point is collaboration with the mainland. As you know, we are striving to incorporate REITs into the mutual access programs. This is an ongoing exercise. I'll now give the floor to the SFC to take the other questions. Yes, Ms. Chan. There is a time limit that is 6 months upon the initiation of a takeover offer. The objection should be made. That is, the objection should be made within 6 months after the takeover offer has been made. What about percentage of minority shareholders? No threshold. What about second part of the question? Who will take this question, please? About effective date of operation of the disclosure provisions. It's about the transitional period. Thank you, member, for the question. On disclosure of inside information regime, the SFC and Hong Kong X have all along imposed the disclosure requirement. System enhancements are needed, so we estimate that this will take about 6 to 9 months. Next, Mr. Johnny. Thank you, Chair. I support revamping the two regimes. I think this will enhance market efficiency. Now, about safeguards for minority investors, I have the following questions. About privatization as well as minority shareholders' interests. Now, the compulsory buyback threshold is 90%. How do you make sure that minority shareholders' assets or interests will be fully safeguarded, especially during voting process when majority shareholders propose privatization or compulsory buyback? Next, about inside dealings, that is market misconduct offenses, the scope will be expanded and there will be a retrospective effect of the law. Will there be clear guidelines to make sure that retail investors will not inadvertently be caught by the law because of ignorance of the new law? I will answer the first question and I'll give the floor to SFC to take the next one. In terms of compulsory buyback, we need to protect the interests of all parties, including minority shareholders. Under the statutory mechanism, minority unit holders can apply for the court to the court for an injunction of compulsory buyback, and according to case laws, the court will consider whether the consideration is reasonable when considering the minority unit holders' application. As for compulsory buyback, an offer can be made in writing for the acquisition of the units, and then the other party can then apply for a court for an order to be made, having considered pricing matters and the terms and conditions. This is the mechanism to guarantee the interests of both parties. I'll give the floor to the SFC to take the next one. About retroactivity of the law, this is a new arrangement, and there is no retrospectivity to speak of. Other provisions to safeguard robustness of the market will continue to be effective. Well, for the new provisions, there is no retroactivity. This is in fact a preventive mechanism. By amending the relevant provisions, we'll be able to prevent the occurrence of offenses. Well, I think it is important about the percentage of minority unit holders, whether it be 2%, 3%, for the mechanism to come into effect. I want further information after the meeting, please. Next, Mr. Andrew Yao.
Thank you, Chair. First of all, I support the administration's proposals because these can enhance the competitiveness of REITs. We have only 11 REITs today. There is definitely room for improvement. Most of the REITs hold real estate that are traditional, for example, offices and hotels. in the mainland, there are different properties such as healthcare facilities, data centers, infrastructure, logistics facilities, etc. We would have holding tax for profits tax in the mainland. We can perhaps communicate with the tax authorities in the mainland so as to guarantee REITs returns purchase in Hong Kong. You have the REIT channel. I want to ask about the latest progress and specifically the progress on being included in the mutual access arrangements. Thank you. Undersecretary, regarding the first question, projects with investments in the mainland, specifically tax matters, we all along have paid close attention to the market situation, and we do keep in contact with the mainland authorities. We have had some preliminary discussions. We are exploring different options. We will continue to monitor the market situation. As for the latest progress of REIT channel, I will let SFC's representatives answer the relevant question. Who's going to answer that question? Yes, Ms. Chen. Thank you, Chair. Thank you, Member, for the question. About REIT channel, we have seen market sentiment improve, and the government has implemented a series of measures, including stamp duty relief. We have recently received many REIT inquiries about listing relevant trust funds. There are also some new asset classes. They have assets not only in Hong Kong, but also in the mainland and overseas. We do understand some potential applicants wanting to list REITs, but they probably want to wait until the mutual access arrangements come into effect before they have their businesses listed or trusts listed. Do you have a timetable? We have close communication with mainland authorities. We have consensus on most of the issues. We are just waiting for approvals to be granted. Once we're done, we will issue a joint notice on both sides. Thank you. Mr. Albert Trung. Thank you, Chair. I support the enhancement arrangements because it will make the REIT market in Hong Kong more flexible. I want to ask about item 5 in Annex 1. I have 2 questions about that, about the explanatory statements to be issued to creditors or unit holders. So we have an asset cap, but within that we can have some investments made to works, but then loans may have to be made with banks. So how would you define creditors? Next, with management companies, will they be required to disclose some forward-looking risk reports on the works projects or some sort of professional valuation reports? If they're not required to disclose such information and there are losses incurred because of that in future, how will we deal with that? Thank you, Undersecretary. I will let the SFC's representatives answer the 2 questions. Who is going to answer the relevant questions? Yes, Ms. Chen. About the mechanism, we have referred to the arrangements under the company's ordinance. It can be arrangements among shareholders or it can be arrangements among creditors. It's not just for property development. For general business, people may make loans. And we have for REITs the loan cap being at 50%. If creditors are involved for the relevant arrangements, all creditors will be involved in an arrangement among creditors, and that would involve all creditors. What about the second question? Well, if a REIT wants to purchase a developing property, the major operator would be a fund manager. If they want to purchase a developing property, we have different requirements in the code they have to comply with. They first would have to make sure this act is in the interest of shareholders. They also need to perform evaluation beforehand. Basically, they would have to comply with the requirements under the REIT code. Alright, any follow-up questions? If not, thank you. Next, Mr. Holden Chow. Thank you, Chair. I support the relevant enhancement arrangements for REITs, but then we did also talk about compromise, and we would ask for sanctioning from the court. I have some questions about that. For arrangement or compromise, when we have winding up or liquidation, there are specific procedures. So if there is any arrangement or the creditor wanting to wind up the REIT, will we go with the provisions under Part 13 in the Companies Ordinance, Chapter 622? Will that be exactly the same? The paper did mention we will have a similar approach as Part 13, but we don't know about the details. Say if a company is subject to liquidation, but in 2 years they are just selling their assets at very low prices to their shareholders, we can recover the funds because we have to protect the interests of minority shareholders as well as creditors. So I want to ask if REITs will have similar treatment. Will we have the same arrangement? Basically, if the company sells their assets at unreasonable prices beforehand. Thank you. And the Secretary. Thank you, Chair. Thank you, Member, for the question. It is as the member understood. We generally refer to the mechanism under Part 13 of the Companies Ordinance. We want unit holders of REITs to benefit from the protection of a mechanism similar to Part 13 of Companies Ordinance. As for the specific similarities and differences, I'll let an SFC representative answer relevant question. Yes, Mr. Thank you, Member, for the question. For winding up, the REIT mechanism will not have the exact same arrangements as that under the Companies Ordinance. REITs are subject to the regulation of the SFC. They have very stringent requirements before transactions are made. They have to issue notices. They are subject to stringent scrutiny by the SFC. This is different from companies. And if a REIT is to be wound up, they need to ask for our approval, and we will make sure the arrangements comply with our standards. Thank you. Mr. Nick Chen. Thank you, Chair. The Liberal Party supports the proposals. We would like to thank the SFC for taking the time specifically to explain to us the specific proposals. I want to ask about paragraph 22A specifically. It says the amendments relating to the implementation of the enhanced market misconduct provisions will be implemented at the earliest time possible. I want to ask if the stakeholders are actually ready for that. Thank you. And the Secretary. Thank you, Chair. Thank you, Member, for the question. I will later let the SFC's representatives give details about the industry's response, I want to emphasize one thing. We have stakeholders, as they're already subject to regulation of existing provisions, they are ready or are ready making relevant preparations. I will now let the SFC representative give more details. Yes, Ms. Chen. As the member said, the provisions relating to market misconduct will come into effect at the earliest time possible because we want to make sure market misconduct such as false trading or market manipulation will be punished regardless of whether they are REITs or companies in general. And we consider these acts as they are breaching relevant regulations. The relevant provisions should come into effect immediately. As for the two other parts regarding disclosures, REITs are already doing this under our code, so they should not have a problem with compliance. With the disclosure requirements being aligned with those for listed companies, we believe they should not have a problem with that. We already talked about that during our communications with the industry, as well as consultation with the industry. What may need some time is to prepare a form for disclosure of interests. We have to wait until the legislation has passed before we publish the relevant form, so that may take some time. Thank you. Mr. Ellen Chan. Thank you, Chair. Let me first say I do support the enhancements. I have a question. However, we have REITs market capitalization being 60% of the total capitalization for listed collective investment schemes, but the turnover is just 1%. So there is much room for us to expand. I want to ask, with this new mechanism, can we form a development blueprint for the REIT market? For example, will we have a timetable for including REITs in the mutual access arrangements so that we can have assets such as infrastructural, logistics, and other facilities come and list in Hong Kong? And how can we make sure to create some sort of synergy with, say, stamp duty relief that we discussed in the earlier agenda item? I believe they have already provided an answer on the question about mutual access arrangements. I'll see what they have to add. Under Secretary. Thank you. We have long adopted a multi-pronged approach. Regarding the member's question, I have an answer that will be divided into different parts. For example, for turnover, we have a large share market, so we may have different components taking up different market share. But for real estate, in the first 5 months, we have seen 489 million Hong Kong dollars. This, compared to 2024, has increased by 31%, and compared to last year, it is about 12.9 or 13%. So we do see a growth. We have already, as I said earlier, different measures implemented. We will soon try to include REITs in the mutual access arrangements. We will also have some tax relief arrangements that are already announced in the budget this year. We will consult the panel on financial affairs, and we will introduce relevant arrangements in the first half of next year. As for the timetable, on including rates in the mutual access arrangements. As SFC representative said, we already have a consensus on the major issues, and we are going through some approval processes. When we get an approval, we will issue a joint notice. Thank you. The last one to speak is me.
提出過
I think this point has been raised by other members. That is, we consider a lot of things from the perspective of market development. About the enhancement of the REITs regime, it includes a number of measures such as M&A, privatization. Now, I think that, to be frank, when it comes to privatization, not much has to be done for the REITs to withdraw from the market. But when it comes to the other aspect, that is, if you want to attract more investment and capital, we need to do more. It's in our DNA. We are good at property transactions. We are an international financial center, so we need to catch up with others. Apart from the traditional Western markets, Japan, Singapore, in other places, they have adopted rather innovative measures. Now, for the CIS regime, there will be enhancements as well to tackle inside information, market misconduct. I appreciate that. But at the same time, how do you address the perception that you are tightening up the whole regime? Will there be over-regulation? Because this will add to the compliance cost, and this will put more pressure on the market. I will give the floor to SFC to respond to the point about market feedback, but let me respond to the first question, and that is in relation to enhancement to the REIT regime. The purpose is to meet market demand. We believe this will be welcomed by the market, and this will encourage other potential issuers to get listed in Hong Kong under the proposed mechanism. The second point relates to the CIS regime. We're going to step up regulation based on two reasons. That is, we want to bring the requirements on a par with those for other listed companies, so as to offer protection to investors in CIS products. Now, as mentioned by the SFC, when it comes to market misconduct disclosure requirements, that we shouldn't, the proposed measure shouldn't add to the compliance cost, because these things are already observed by the market players anyway. Let me supplement. We conducted public consultation. We received positive feedback from the sector, as pointed out by the Undersecretary. We in the UK, Australia, and Singapore, there are similar arrangements. We want to enhance Hong Kong's competitiveness. Now, on the market withdrawal, in fact, this amendment relates to M&A and restructuring as well. Now, for REITs, this amendment will bring vibrancy to the whole sector. Thank you for answering our questions today, FSTB and SFC representatives. Now, let me ask members. The administration plans to submit the amendment bill to LegCo later this year. Is there any objection? If not, I see that members are in support. Let me thank the SFC and the administration for coming to our meeting. We now move on to item 5. That is proposed amendments to the Securities and Futures Stock Market Listing Rules. Members, if you want to speak, please press the Request to Speak button. let me invite the administration as well as representatives from other parties to come in. So, we're joined by the FSTB as well as the SFC representatives. So, when you're ready, Mr. Joseph Chan, Undersecretary for Financial Services and the Treasury, would you like to present the paper to us? And please do allow time for members to ask questions. Thank you, Chair. Members, good morning. I'm joined by the SFC representatives, and I'd like to brief members on the proposed amendments to the Securities and Futures Stock Market Listing Rules, CAP 571V SMLR. Hong Kong is a major listing platform for the world, and the government has been working with SFC and Hong Kong X proactively to continuously review the listing mechanism and approval process with a view to balancing market development and regulatory needs. Now, to attract more quality entities to get listed in Hong Kong, we have put in place a number of reform measures, such as the listing regime for specialist tech companies, enhancement of the listing framework for overseas issuers, as well as the launch of the Technology Enterprises channel to assist enterprises in preparing for listing applications. In fact, we have also optimized the approval procedures. In 2025, we recorded 119 IPO applications with a market capitalization of $280 billion, up by 20%. We ranked the first around the world, and this year we've continued to take forward this momentum, and as of the end of June, the IPO size has reached $200 billion. Whilst promoting market development, the government ensures that by joining hands with the SFC and Hong Kong X, we roll out measures to enhance market quality and offer greater protection to the interests of investors. The SFC has conducted a holistic review of the rules and proposed amendments to encourage higher transparency for applicants and more accurate disclosures and also so that there will be more tools available for SFC to tackle market misconduct. The proposal seeks to enhance efficiency and flexibility. Now, there are 8 proposed amendments. You'll find details in paragraph 7 all the way to paragraph 21 of the paper. For example, about withdrawal of objection notices by the SFC. This will be allowed for the applicant to proceed with the original application without making a fresh one. The second proposal is continuous conditions applicable upon and after listing, so that these conditions will remain effective both upon and after listing to provide flexibility. The third proposal is to allow SFC to impose post-listing conditions and also a condition for continued trading without causing market disruption by suspending trading. The fourth proposal is to amend, revoke, or impose conditions where necessary, so that SFC can take regulatory action if necessary in light of at the post-listing stage. The fifth proposal is to simplify resumption procedures, and that the board is empowered to make decisions on resumption of trading so as to expedite the resumption processes and shorten the suspension period. The sixth recommendation is to expand the scope of power, and that is the SFC can request issuers to provide information on requests during the post-listing stage. Seventh proposal, SFC's decisions can be reviewed by the SFAT Securities and Futures Appeals Tribunal to ensure that the decision will remain fair and unprejudiced. The eighth proposal is removal of exemptions for preemptive pro rata issuances and employee share option schemes, so as to, the automatic exemptions will be removed so as to provide greater protection to investors and to tackle abuse. The SFC conducted market consultation between March and May 2025 on the proposed amendments with majority support from the market. Subject to members' views, we plan to submit the legislative amendments to LegCo within 2026 and would like to tap members' views today and will also be responding to members' questions. Thank you, Undersecretary, for your introduction. I now open the floor for questions and answers. Each member will have 3 minutes, Q&A included, starting with Ms. Carmen Khan, Champui Lang, Ronnie Chan, Michael Ngai, and Howden Chow. Ms. Carmen Khan. Thank you, Chair. The Undersecretary just briefed us on the 8 proposed amendments. I support all of them. I find these amendments necessary so as to enhance market interactivity as well as flexibility. For example, if the SFC objects to the listing application, there is no withdrawal of notice. The applicant must submit the application afresh. As for conditions imposed after listing, they will lapse upon listing of the entity, and that there is no delegation of power to ask for information under the current mechanism. Now, my view is this: how do we strike a balance that is while boosting interactions between SFC and the market? How do we make sure that there is a proper balance between regulation and market development? Now, next, I also welcome the review of decisions by the SFAT, that is the tribunal, because this can enhance the independence of the tribunal. But how do we make sure that the SFAT will be supported by more resources? Undersecretary, thank you, Chair, and thank you, Member, for the questions, and thank you for your support. As I said in the opening remarks, there are a series of enhancement measures to enhance market efficiency, flexibility, and more effective interactions. Now, on striking a balance between regulation and development, as well as reviewing the SFC's decisions, I will give the floor to the SFC colleague. Ms. Choi, thank you, Ms. Khan, for the questions. Now, about striking a balance or maintaining a dialogue with the sector, SFC will promulgate a set of guidelines soon. On a regular basis, we will conduct a review and update the provisions on, for example, conditions to be imposed and implemented. That is, we will gauge on the experience to see what conditions may be imposed under what circumstances to enhance transparency. Of course, we are empowered to tackle serious market misconduct cases, whereas for the general administrative procedures, before imposing any condition, we need to issue a letter of concern, and we need to suitably inform the listed entity for it to make representation first. And if an appeal is lodged under the proposed arrangement, the SFC's decisions may be reviewed by the SFA tribunal. On resources, I'm sure that the government maintains close liaison with the tribunal. I think that the extra work can be absorbed by existing resources for the time being. Undersecretary, let me supplement. The Securities and Futures Appeals Tribunal is an independent entity. upon receiving applications to hear cases. We will ensure that sufficient resources will be provided to the tribunal. In fact, in the past few years, this tribunal has not heard many cases, but we'll make sure that additional resources are provided.
Next, Mr. Chen Pulang. Thank you, Chair. First of all, I would like to express support to the proposed amendments regarding SFC being able to impose continuing conditions applicable upon and after listing. I want to ask, does it mean essentially the company is listed under certain conditions? Do we ask the companies to disclose such in their prospectus for listing so that the public will know about this? Also, will the conditions be permanent or will they only be valid for a period of time? We now have other arrangements other than suspension of trading that would perhaps involve imposing conditions on the companies. And the basis for the SFC to do that would be the code of the SFC. But if the company does not comply with the conditions because this is administrative in nature, will that incur a greater loss on the public as time goes? Thank you. Undersecretary. Thank you, Chair. I will let the SFC's representatives answer the two questions of the member. But in principle, the companies are subject to regulation of SFC, but they have noted some circumstances that do not affect the listing. But there are some concerns. They will impose certain conditions. As for the specific considerations, I'll let the SFC's representatives provide more details. Ms. Choi. Thank you, member, for the question. Before or upon and after listing, we can impose certain conditions for specific acts of the company, but in accordance with administrative law, we need to be reasonable and proportionate in the use of our powers. So, more likely than not, the relevant conditions will only be valid for a period of time. Let me give you an example. For some of the previous applications we received for listing, for certain transactions with associates, we want the company to disclose such transactions in the accounting report that is to be published upon listing. We will make clear of that. We will also ask the companies to make clear of such in their prospectuses and in any other public disclosure documents. As for whether this may incur a greater loss for the public, we want to say this. We don't want companies to suspend trading because it will definitely be a loss to minority shareholders. As for whether we should allow trading to continue, we need to have in mind public interest. If there are some conduct concerns on the part of the management that it can be quite serious, we may conduct an independent review. We will ask the companies to enhance internal monitoring. We're trying to strike a balance. We don't want companies to suspend trading, but we don't want to hurt the public in the process either. Thank you. Mr. Chan Chen-ying. Thank you, Chair. I support the different proposed amendments. I have 2 questions. First, on the simplified resumption procedures. I note right now boards are required to have at least monthly meetings, but to enhance efficiency, you may delegate the relevant powers to executive committees. So if you are delegating the powers, I believe you can have meetings more frequently, but will you also shorten the notice period? I also want to ask, will you give a list of which types of cases will be seen as non-disputed? I want to ask about the appeals tribunal. Apparently there are 25 members on the membership of the tribunal at the moment, and they're experts from different sectors. I believe the tribunal can definitely be independent. But then I also want to ask, for serious cases, you will penalize them by not allowing them to issue shares. So I want to ask, will the powers of the board to determine that be delegated to other committees as well? Thank you. Under Secretary, thank you. Chair, thank you, member, for the questions. But let me say, in principle, the board will still be the main determinator of any decision on resumption of trading. But the board may consider delegating certain powers to the executive directors or executive committees of the SFC. For the specifics, I will let Ms. Choi answer the relevant questions. Thank you, Chair. Thank you, member, for the questions. I don't think we need to specifically define the non-disputed cases. In our communication with issuers, as long as there is an agreement, the board will delegate the specific powers to executive directors. And the companies will definitely be aware of that. So in the end, the decision should be left to the board. As for tribunal, they will act relatively independently, and what you said earlier would be included in their scope of review. Thank you. Professor Michael I welcome the proposed amendments, especially about those in paragraph 7 and 8 about withdrawal of objection notices so that companies can continue with their original applications. The costs will not be wasted. But I want to ask if you will have specific time frames to provide clearer expectations to the trade. Will the government consider setting out in the relevant rules how many days within which assessments will be made and notices be issued? Does the government have specific measures to prevent there being a backlog so that it would not increase costs for enterprises? I think SMEs really need flexible financing options as well as employee share options to be attractive. And in paragraph 21, the SFC said they would only intervene in very serious cases, but it is sometimes very hard to delineate the line. So, will we provide different degrees of support to enterprises of different scales or issuers of different scales? Thank you. Undersecretary, thank you. I will first want to thank the member for expressing understanding and support for our goals. We want to allow the SLC to allow companies to continue with their original applications so that the whole process is more efficient. Regarding what is said in paragraph 21 about the specific exemptions for pro rata issuances and employee share option issuances, as said earlier, the SFC will only intervene in highly suspicious circumstances. We want to provide support to issuers of different scale. I will let the SFC's representatives talk about the specifics. Yes, Ms. Choi. Thank you, member, for the questions. Regarding withdrawal of objection notices, in fact, we already had some enhancements implemented in 2024 along with the HKEX. We would have completed IPO approval processes within 40 working days. As well, that will be a benchmark we adopt in future for listing in future 40 working days. We do not expect a lot of companies taking advantage of the specific tools. For example, for secondary offering or issuances, we will only make use of our enforcement tools when necessary. We will make sure to issue guidelines to issuers. If specific issuers have any questions, we're more than willing to answer their questions. Please rest assured we maintain communication with the industry. We cannot discuss individual cases here, but basically we have before provided guidance and training to stakeholders to enhance their understanding. Well, the member said specifically SMEs would have less resources than larger enterprises, so we hope the regulator can provide more support. Thank you, Mr. Holden Chow. Thank you, Chair. One of the enhanced arrangements is for the SFC to withdraw the objection notice so that applicants don't have to submit applications anew. I think that is facilitative, so I definitely support this. I want to echo on a point made by Professor Michael I. In paragraphs 20 and 21, if companies abuse the additional issuance mechanism, the SFC can intervene. But let me just say this. These arrangements do this on a routine basis. If you suspect misconduct, you can definitely intervene. But I hope the SFC will provide some sort of guidelines to the industry. I'm not asking you to give real life examples, but perhaps you can give some examples on what will be seen as justified reasons for additional issuances, such as to incentivize employees. That's definitely justified. I think you can allay concerns of the industry with that. As the chairman said, SMEs may not have as many legal resources as larger listed companies do. So it may take some work for the SFC to explain to them what the requirements are, and I hope you can make clear of those in your guidelines. I think it would be great if you can provide some clear guidelines. Thank you.
多謝議
And the Secretary. Thank you, Chair. Thank you, Member, for the comments and questions. About removing the mechanism of preferential shares and also automatic exemption for preemptive prorated issuances, employee share option issuances, in line with the policy objective. For the purpose of compliance, we will not, or we should not cause any disruption or impact on normal operation. However, for some cases, it's a departure from our policy intent. For example, the employee share option schemes may involve some other operations behind, such as the interests of owners, interests of option shareholders, and that there is a concern that requires our intervention. But we take members' views when it comes to reforming the mechanism. The SFC will promulgate guidelines and will continue to liaise with the sector and will provide support to SMEs. I'm the last one to speak on this paper, and I'd like to make a comment. In recent years, the government has rolled out market enhancement measures to, for example, expedite the vetting of listing applications in order to attract leading enterprises to get listed in Hong Kong. I'm seeing some results now. In relation to these proposed amendments to the listing rules, I feel that some issues have been addressed. For example, withdrawal of objection notices, and also conditions to be imposed to enhance market efficiency so as to shorten the suspension period, and also withdrawing the objection notice will avoid having the applicant submit fresh applications from scratch. These are all beneficial to the development, but how do you make sure that by imposing conditions post-listing, that the public will not be having this perception that the entity is now on the watch list? The listed entity will have to continue to meet certain expectations. I fully appreciate that. But then, according to the sector, the SFC is now given even more tools, and that the entities will need to meet many more conditions even after it has been listed. Under the SFO, currently, there are provisions that empower the SFC to request information. I understand the reason behind, but you need to explain why, on top of the existing legal framework, you're adding more to it so as to strengthen control. This will put pressure on the licensee or the issuer, since the SFC can request information from multiple channels. Can you explain that? Thank you, Chair. The SFC will respond to the question from their perspective, but let me first start by explaining that the series of reform measures seek to enhance the efficiency of SFC's supervision and vetting of listing applications. We want to keep things flexible as well. Chairman, you explained that indeed there are tools for SFC to tackle market misconduct. For example, originally, the entity will have to be suspended from trading, but now we allow continued trading subject to the meeting of conditions post-listing to avoid suspension of market trading. We want to strike a balance between regulation and market development. We also want to enhance investors' protection through introduction of these measures. As for the specific details, I will give the floor to SFC. Thank you, Chair, for your comment. In using these tools, we will make sure that they are used in a reasonable and proportionate manner. I'm sure you appreciate our objective, and that is to ensure the quality of the market and to bolster our status as an international financial center. I think, of course, it's good news to everyone that we have performed quite well in the IPO market. But likewise, you may have noticed that there are a number of cases involving suspension right after listing because the auditor is unable to provide comment, or that there are less than ideal situations involving misconduct. We only impose conditions in more serious cases. This will not be done casually. So with the amendments in place, we will be able to allow entities to resume trading, subject to conditions. At the same time, we will provide better safeguards for investors in terms of request for information or transparency, internal control, etc. Right, thank you, FSTB and SFC, for coming here to take members' questions. Now, the administration plans to submit a legislative amendment proposal to LegCo within this year. Any views? Right, all in agreement. Thank you. Thank you for attending today's meeting. Moving on to item 6. Legislative proposals to enhance the recovery process of default MPF contributions and MPF regulatory regime. Members, if you want to speak, please press the request to speak button. I will invite the administration and representatives of the MPFA to come in. The FSTB's team will stay behind, and let me also welcome representatives of the MPFA to the meeting. Let me first invite Mr. Joseph Chan and the Secretary for Financial Services and the Treasury to deliver an introduction. Over to you. Thank you, Chair. The government and the MPF Schemes Authority, MPFA, proposed to amend the MPF Schemes Ordinance in order to enhance the process for recovering default MPF contributions from non-compliant employers. We'd like to seek members' views on the relative proposals. First, on enhancing the recovery process of default contributions under the current MPF system. For employers defaulting on mandatory contributions, if they are in breach of the law, they will be subject to the payment of a surcharge imposed on late payments up to 5%. And all the surcharges and the payment in arrears will go under the affected employee's account. In order to enhance the incentive for them to promptly settle the outstanding contributions, we propose to amend the regime so that a two-tier surcharge system can be introduced, and that the non-compliant employer will be subject to a second-tier surcharge equivalent to 10% of the outstanding amount. A sanitary notice can be issued by the MPFA to the relevant employers for suspected default MPF contributions, and that the information should be submitted within the specified period so as to enhance efficiency and for civil claims to be filed in a timely manner. And this can help the MPF in filing civil claims against the employer for the employees. The second aspect is to relax the relevant income information so as to enhance the risk management tools. There will also be a relaxation of the investment aspect so that managers will have a more relaxed scope, and that there'll be more flexibility to buy funds with a high rate of return. And about the disciplinary action mechanism against trustees, the MPFA can take the following disciplinary actions. There can be a public reprimand on trustees. There can also be a pecuniary penalty imposed. Now, on penalizing non-compliance acts, we propose clear stipulation of the conduct requirements in the provisions when carrying out regulated activities so that the interests of MPF members can be safeguarded. I will now give the floor to my MPF colleagues to give you more details. Yes, Mr. Chang, Executive Director. Well, as pointed out by the Undersecretary in his opening remarks, employers are responsible for making mandatory contributions to the employees according to the law, and that there is a clear stipulation on when the payment should be made. If the employer defaults payment of the contribution according to this diagram, there is a surcharge mechanism that imposes a 5% surcharge, but then it's an across-the-board amount. Now, we emphasize that all the overdue settlement as well as the surcharge will go under the employee's account. However, the existing surcharge does not increase even if the non-compliant employers continue to default on contributions, and this diminishes the incentive for the sum to be settled. We propose to introduce a two-tier surcharge. That is, on top of the current level of surcharge, there will be a second-tier surcharge. If the employer fails to settle the overdue contributions and the surcharge within 120 days from the contribution day, a second-tier surcharge equivalent to 10% of the outstanding amount will be levied. Again, all these sums will go to the employee's MPF account. The second-tier surcharge should be pitched at a higher level than the first-tier surcharge in order to reflect the severity of defaulting MPF contributions, and this can also provide incentive and deterrence for non-compliant employers to rectify the situation as quickly as possible. As for 120 days from the contribution day, we have taken into account the experience in handling default cases in the past, and that we consider that there should be sufficient time for the suspected non-compliant employers to make payment. Now, against this backdrop, let me show you the next diagram. That is assuming that the employer makes timely contribution, the employer will not be subject to the first or second tier surcharge. So that's the picture on the left hand side. For the right hand side situation, now if the employer defaults the mandatory contribution, and that under the current mechanism, this will be subject to a surcharge. Some employers are encouraged to settle part of the sums, and this can help lower the surcharge, according to the formula.
咁另外咧就係、如果
And if the employer continues to fail to make relevant mandatory contributions, the MPFA will proactively take action, including lodging claims for affected employees. Now, the RI information is very important for us to find out the specific amount owed. So the MPFA will issue a demand notice for the employer to provide relevant income information of employees within 14 days. The MPFA may impose a financial penalty on employers who fail to comply with this. The MPF regulatory regime, which we plan to enhance as well, we want to provide better potential returns. We have 4 proposals in mind. One, we want to relax restrictions on fund structure so that MPF funds can invest in both categories of fund building blocks. We also want to expand risk management tools to allow MPF funds to use interest rate swaps. We want to also permit MPF investment managers to delegate investment management functions to a non-associated investment manager. We also want to have some technical amendments made to allow MPF conservative funds to invest in debt securities with longer maturities. We also want to empower the MPFA to issue a remedial notice to the trustee in the event that an MPF fund contravenes the investment-related requirements, and the MPFA may take disciplinary actions against those who fail to comply with the requirements of the notice. The MPFA can already take some disciplinary actions at present, but they are restrictive. There are more serious penalties, but for the lighter penalties, we only have fixed penalties and administrative punishments. We want to provide more disciplinary action options to the MPFA, for example, to publicly reprimand the trustees, and they can issue pecuniary penalties that are not fixed penalties. That is, it can not exceed the greater of $10 million or 3 times the amount of profit gained or loss avoided by the trustee. This is in line with other financial regulatory regimes of the city as well as international practices. Basically, we want to record the facts of disciplinary actions on a public register as well as a follow-up action. we want to specify the mechanism by which trustees may appeal against MPFA's disciplinary decisions. We also propose to adjust the deadline for trustees to file an appeal to 21 days. This is in line with the regimes for securities and insurance industry. I think you should be brief because we have multiple members wanting to speak. Well, this is already the very last point. We already talked about actions against trustees. We also have actions against MPF intermediaries. In previous cases, there are some gray areas for whether one is selling certain products. So we will include such activities in the scope of disciplinary actions. We also have other technical amendments which I will not go into the details here. We have consulted stakeholders on the proposals for enhancing the recovery process of default contributions. The employee side in general supports this. For the employer side, they want the penalties to be proportionate to the degree of breach. We will put in place a grace period, and we have considered stakeholder feedback on this. As for the enhancements to the regulatory regime, we have received general support from stakeholders. If we also have member support today, in Q4 of this year, a bill will be introduced into the council. That's it for my presentation. Thank you. We'll now open the floor for members' questions. We have multiple members wanting to speak. I will assign a 3-minute time limit. Let me read out the order in which members are going to speak. Mr. Ray Wong, Mr. Ken Lee, Mr. Lam Chen Sing, Dr. Webster, Mr. Jonathan Stewart Lamport, Mr. Chen Puila, Mr. Yu Ming, Mr. Holden Chow, Mr. Chao Su Chong, Mr. Ellen Chan, Dr. Johnny, Ms. Carmen Khan, and Mr. Lam White, called Mr. Ray Wong. Thank you, Chair. We talked about multiple enhancement legislative proposals today. I must speak for the industrial sector that is definitely struggling at this moment. We, of course, want to provide great retirement protection for employees. But while we are still in recovery, if we are to pay more in contributions and on top of that we are penalized more, it will punish those who are truly in a difficult position rather than those who are maliciously defaulting on contributions. We should not take an across-the-board approach. We should also distinguish between those who are careless and those who are malicious. If you are asking the employer to give a reply within 14 days, and for the first contravention, one will already be fined $10,000. This is very harsh for SMEs. The EMPF is not exactly a convenient platform to use, and if they are just missing deadlines because they were careless, this penalty is too heavy. We need to make sure there are proportionate penalties. Regarding the two-tiered surcharge, we should have a grace period, and you would have for outstanding contributions for 120 days. It would make for a 15% penalty, and this can be a very harsh penalty for SMEs. When SMEs are already in a difficult position, this can be the very last straw. So I hope there will be a grace period of 12 days, and if employers cannot meet the deadline due to perhaps system error and other careless mistakes, grace would be offered to the enterprises for 12 months. Thank you. Undersecretary, thank you. Chair, thank you, member, for the questions and comments. I would first give some give a reply, and the MPFA's representatives can supplement my reply. Right now, we already regard employers who do not pay mandatory contributions on time to be in breach of the law. As for how we can provide support and reduce administrative issues so that employers can make contributions on time, I will ask the MPFA's representatives to talk about what specific support measures they have. We want to introduce the amendment bill in Q4 of this year on enhancements to the regulatory regime. We will decide on the specific timetable and arrangements when we draft up the bill. I will now let MPFA's representatives supplement my reply. Thank you. I would like to emphasize that most employers are making contributions on time in accordance with the law. Regarding what Mr. Wong said, those who are malicious and unscrupulous, we do want to punish them. And we have a second-tier surcharge, only after the contributions being outstanding for 120 days. So this surcharge is not imposed right away. We consider this reasonable. As for the demand notice for relevant income information, we do not ask employers to submit such information immediately either. If employers delay submission of such information or does not submit such information, and we suspect that they are acting maliciously, we will ask them by issuing a demand notice to provide such information within 14 days. So a clarification I would like to make is that we will only impose penalties based on the actual circumstances to compel those who are acting maliciously to provide information to protect scheme members' interests. Thank you. Mr. Can Lee. Thank you. Chair, I very much support the legislative proposals relating to the enhancing of recovery process of default, MPF contributions, and MPF regulatory regime. For the surcharge, at present, it is just 5% uniformly. It is unfair to law-abiding employers. It cannot compel those who are defaulting on contributions to settle the contributions as soon as possible. So I do support the relevant proposals. Regarding what other members said, for the malicious ones, should we have an additional tier for them to impose on them harsher penalties? And in the end, the surcharge is not credited to the MPFA, it is credited to employees. Regardless of whether the surcharge system is 2-tiered or 3-tiered, I want to ask that we make sure we do not see an increase in costs with this. We will also have disciplinary actions taken against intermediaries. Again, this is beneficial to scheme members. We have already some examples under footnote 5, but we should have more guidance on what specific action that may entail, that may constitute offenses, so that intermediaries can have reference to that. Thank you. Under Secretary. Thank you, Chair. I will answer the first part of questions, and then I'll let the MPFA's representatives answer the second part. I thank the member for supporting the proposals. As the member said, we have a two-tiered surcharge system to compel basically or have the defaulting employers to settle the contributions as soon as possible. The MPFA can also initiate criminal prosecution against employers. So we have always practiced somewhat stringent regulation. And as the member said, in the end, the surcharge will be credited to the accounts of employees who are affected. As for whether we will have an additional tier on top of the two-tier system, we think there are diminishing marginal returns if they fail to settle the contributions when they are charged the second-tier surcharge. They may not pay still when they are charged more. So, as I said earlier, what we can do is that the MPFA can initiate criminal prosecutions, and the MPFA may also act early on to issue an information demand notice to relevant employers to request for relevant information. There are different measures that the MPFA can implement. As for disciplinary actions against intermediaries, I'll let the MPFA's representative answer the questions.
Yes, responding to manpower and resources, I want to emphasize that the two-tier surcharge is something new, but we do have the existing manpower resources to take up the extra work. About system enhancement or streamlining procedures, no additional resources would be involved. As for regulating intermediaries, as I explained in the opening remarks, you only target regulated activities, that means selling activities. As for other unregulated activities, meaning misconduct or non-compliance, well, the law doesn't spell them out very clearly. That is, for example, the intermediaries may make use of the personal data of the data subject without consent to carry out certain activities, such as switching from one scheme to another. Now, this is misconduct, and the current law doesn't seem to make it clear enough, and we hope by amending the legislation we can provide more details explicitly. That is, for these non-compliant improper acts relating to the MPF, they are subject to regulation. And when it comes to compensation, any non-compliant act will be causing losses on the part of the scheme member will be subject to the compensation process. Right, let's be brief. We have a lot of members waiting in line. Mr. Webster, Mr. Lam Chen Sing, I need to declare that I'm chair of the MPF committee. I want to ask if there will be sufficient deterrence. Say, if an employer defaults on the MPF contribution up to the limit, we're talking about $15,000. According to the two-tier surcharge, the second-tier surcharge may just be $2,000, and that the employer can default up to 4 months. Is it strong enough a deterrence? Say, now, if the employer then makes contribution late for 3 months together with surcharge, that's 10%. Shouldn't we take a progressive approach, say up to 15%, to put more pressure on non-compliant employers? The next question is, for employers who are recidivists, they should be subject to another tier of surcharge, and that is 15%, so as to put pressure on the non-compliant employers for them to make timely contributions and payment of surcharge. Thank you for the questions. For the second question, I'll give the floor to the NPFA. Now, let me take the first question. I hope members will understand that the second tier surcharge is proposed to provide incentive for non-compliant employers to make payment as soon as possible. For defaulting NPF employers, they are in breach of the legislation, and we have tools in the toolbox, such as a surcharge and criminal prosecution by NPFA against the non-compliant employers, as well as a request for information about the income of the employer, so as to help NPFA file a civil claim on behalf of the employees as quickly as possible. So there are different tools. Regarding additional tiers of surcharge, I think we need to first study the impact on employers first. We have the whole toolbox, which makes things more effective. And the NPFA will respond to the second point. Well, to answer Mr. Lam's question on repeated offenders, we don't take action from the beginning. We start with filing a civil claim right away so that we can leverage on the court's orders to done the outstanding payment. So for recidivist, we will start with civil claims to go after the outstanding payment. Mr. Webster, I need to declare that I am an NED of an EMPF. I am concerned about three things. First, about the second tier surcharge to be paid within 120 days. Now, you mentioned that for minor offenses they will be covered as well. Now, the bill won't be tabled until the fourth quarter of this year. Will you consider setting up a transitional period to issue warnings or to follow the practice under 82A of the Inland Revenue Ordinance, so as to allow discretion to be exercised? Because for SMEs, they may need time to get used to a new system, and they may be inadvertently caught by the law, and this may impact on their cash flow. The second point about public reprimand and record to be made on register for 5 years. I'm concerned that if the entity is, or the parent company is a listed entity, then in the ESG report the disclosure will be required, and this will somewhat impact on the stock prices. I want to know if the Hong Kong X and the Hong Kong CPA have been consulted. The third point is a technical one about request for information, requesting information of income. Now, I want to know for the same employer whether you count only one notice or multiple notices as one. For the three questions, I will let the NPFA give a more specific response. I want to emphasize, however, that if an employer fails to make contributions, then it's against the law. This is clear. So it's hard to say that this employer deserves any leniency or more relaxed approach, because it's a breach of the law in the first place. About the three technical questions, I'll give the floor to the NPFA. Any transitioning period beyond the 122 days, we can give it a thought. This is a legislative proposal. We have not actually begun the drafting stage, so perhaps we can discuss further whether to introduce a grandfathering arrangement. Our preliminary view is that 120 days are long enough. we don't impose a 10% second-tier surcharge right away. At least there will be a period of 120 days, which is rather long. About public reprimand, as mentioned by the member, and also registering in the open register. This is the current arrangement, in fact. Now, we've come across cases involving intermediaries of the principal, which is a listed company, and we make announcements only after the market is closed, in line with the existing practice of the SFC or the Hong Kong MA. As for the third question, I'll give the floor to Mr. Chang. Very briefly, according to the legal framework, we count the number of contraventions. According to the current laws, after we issue a notice, they will be required to follow our or accede to our request to provide information about these default cases. We do it in batches. In other words, say in a month, if the same company bails on the contribution of a number of employees, then we'll issue one notice covering all the breaches. However, we need to keep things flexible because in some cases it's for individual employees to come forward to make a complaint first. So we don't rule out the possibility of issuing a notice that prioritizes the complainant, but on the whole, we usually issue notices in a batch to cover the all the default contributions. Mr. Jonathan Lampert, the Hong Kong GCC supports the proposal, but we are concerned and we have reservations about the two-tier surcharge. I don't think the two-tier mechanism truly handles different irregularities. It's too rigid. So we should introduce a surcharge mechanism based on interest payment. This will be a more fairer approach because of the poor economic outlook and the uncertainties. Many SMEs are not making profitable businesses. If they are subject to heavy fines, this can exacerbate the situation. And this can hamper Hong Kong's competitiveness because of worsened job security and stability of MPF contributions co-payment mechanism in the long run. Now, if we peg the penalty level to the interest rate, we can then calculate the exact amount of penalty on the basis of the length of default and the interest rate, and this can help avoid putting too heavy a burden on employers who are in financial hardship anyway. I want to make sure that the penalties will not be too harsh for the sake of the economy. Now, the other point is this. The MPFA is empowered to issue a notice to request information within 14 days, and that for non-compliant employers, they'll be subject to civil claims. If they're not able to provide information, they'll be fined $10,000 for the first time and $20,000 on subsequent offences. Now, I'm concerned that how the calculation is done. Is it by the number of employees? Say if a restaurant hires 100 employees, we're talking about $1 million in total. So I want to know the basis of calculation. The next point is about request for information. Under the new mechanism, employers will be required to submit information within 14 days. And if the MPFA is to file a civil claim on behalf of the employees, by how much will the processing time be shortened? Under Secretary. I'll give a policy response first, and then the MPFA will take the second question and see if they have anything to add. I want to emphasize that it is the employer's responsibility to make MPF contributions. Failing to do so will be a breach of the law. The current mechanism covers a 5% surcharge. We want to introduce a second tier surcharge to encourage employers to pay up as quickly as possible. According to members here, employers may default the contribution for various reasons. That is why employees will be subject to an additional 10% second tier surcharge if they fail to pay the outstanding sum after 120 days, and that is sufficient buffer. I hope members would appreciate that. Now, about the suggested basis of calculation on the floating interest rate for the surcharge, I want to explain to members that we want to keep the mechanism simple and accessible. Many SMEs are fully aware of the two-tier mechanism, 10%, 20%, and also 120 days period. If we adopt a floating interest rate approach, it will turn the simple formula into a complex one. This will also add to the administrative cost of the platform. So for members, they will also find it hard to do the math. It will be difficult. I will give the floor to the MPFA to respond to the rest of questions.
Mr. Ching from the MPFA. Thank you. To give a brief reply to Mr. Lamport's second question on the issuance of demand notice, if employers deliberately defaults on contributions at present, we can't do anything. We have to ask for employees to provide information. If they do, we can do something. If not, we can't do anything. So basically, with the proposals, we can provide better protection to our employees so that they can receive their contributions on time. Thank you. Mr. Champulin, thank you, Chair. I do support the relevant legislative proposals, and I think we would agree the two-tier surcharge system is to punish those who are defaulting on MPF contributions on purpose. But on the other hand, for those who are defaulting purposefully, you can't really do much. Can we ask perhaps employers to provide audited financial statements so that we can find out whether the employers are indeed in a difficult position? And for those who are actually in a good enough financial position, we should have more, we can have harsher penalties. Perhaps we can have higher pecuniary penalties for them. Perhaps this can be more effective. We have one of the enhancements to the MPF regime being relaxing the restriction for investment mergers so that we can have non-associated investment managers make investments. But what is the delineation of liability and compensation responsibility? How can we make sure in operation it will not result in an outsourcing of duty? Thank you. Undersecretary, thank you, Chair. I will have the MPFA's representatives answer the two questions. Yes, Mr. Ching. Thank you, Chair. Thank you, member, for the questions. On the first question, the suggestion made by Mr. Chen on companies providing audited financial statements, I want to first say this. Right now, we have a blanket 5% penalty for whether one is defaulting on contributions for only 1 day or 100 days. So our proposal is quite simple. If the amount remains outstanding for long, up to 120 days, after 120 days, we will impose a second-tier surcharge. This, in a way, will encourage employers to pay the contributions early on. If we have to scrutinize companies' financial statements to see whether we charge the surcharge, we will lose this incentive essentially for companies to or employers to settle the contributions as soon as possible. I will now ask my colleague to talk about delegation of powers. Yes, Mr. Eric Cheng. We do allow for delegation of powers, but the responsibility, the delineation of which is very clear. Trustees are fully responsible for the operations of MPF, and they have the responsibility to supervise other investment managers they have appointed. If there are irregularities, trustees have to deal with them as soon as possible, and if scheme members suffer a loss as a result, they have to compensate for the losses. Thank you. Mr. Yu Ming. Thank you, Chair. I think if the amount remains outstanding for longer, there should be harsher penalties. We have had before cases in which employers have gone into liquidation or gone bankrupt that they're just defaulting on the contributions altogether. We have millions of workers in Hong Kong. We want to make sure the penalties are deterrent enough for employers, but then we should also offer some flexibility to SMEs. We have been enhancing MPF investment arrangements to provide more options and enhance flexibility. I want to ask if the Bureau has specific measures and to enhance the contributions made by employers and employees and data relating to growth, if any. Thank you. Secretary. Thank you, Chair. Thank you, Member, for the questions. Let me provide some information. If we look at recent performance of MPF funds, in 2025, the net returns with costs and charges deducted is 16.6%. So for the 6 types of MPF funds, stock funds, mixed asset funds, bond funds, conservative funds, guaranteed funds, and money market funds, they all recorded positive returns. With the different figures, you should note that we have continued to see an expansion of MPF fund, and last year we have recorded positive returns across the board. We should look at things from a long-term perspective. As at end of May this year, since the implementation of MPF arrangements, the average annual net returns is 4.2%. It is higher than the 1.8% inflation. So I hope this can be of reference to members. I will now ask the MPFA's representatives to answer the other questions of the member. Mr. Cheng Yanqi, thank you. Chair, the member asked about defaulting on contributions. We want to make sure employees are paid the defaulted contributions as soon as possible. With the specific arrangements, we believe it will make employers settle their contributions faster. Before, we would just try to pursue the employers as much as possible, and in the end, we would have to lodge civil claims in court. Some companies would go into liquidation, As the members said, as there cannot really operate for longer, so they had to go into liquidation, and we couldn't really do much on the defaulted contributions. It took much time for the employees to receive their contributions in the end. With our proposals on this occasion, we hope that affected employees won't have to wait that long to receive the contributions they should be paid. About the second question of Mr. Yu Ming about enhancement of regulatory arrangements, I believe with our different measures, it will increase returns to MPF scheme members. As for the specific figure, it may be hard to estimate now, but we want to take this direction so that the regulatory regime can be flexible for fund managers and trustees to strive for better returns for employees. Thank you. Can I perhaps ask the administration's representatives to provide how many cases there are where we cannot recover contributions? Sure. It's close to noon now, and we'll extend the meeting to allow the 6 remaining members to speak. Mr. Holden Chow. Thank you, Chair. Apart from legislative proposals to enhance the recovery process of default contributions, there are also proposals on enhancing the MPF regulatory regime to allow delegation of powers to some other fund managers, as well as enhance flexibility of investments. I believe the administration is definitely justified to do that. I want to ask some questions on this. Often, we have fund managers have different portfolios, and in fact, recently we passed a bill relating to the insurance sector, where the insurance sector would invest in local infrastructure bonds, and this helps support the local bond market. I note in paragraph 9 of the paper, MPF investments can now include debt securities. I want to ask, with the relaxation of restrictions, would you allow them to invest in local infrastructural bonds to support the development of the local bond market? Since you already talked about a related enhancement in paragraph 9, would you consider this? Thank you. Undersecretary, how we can perhaps prioritize MPF investments made to infrastructural bonds or bonds of the city in general. This is all along in our minds. The Hong Kong Monetary Authority and MPFA already have a prioritization mechanism, and in June 2023 and June 2025, these arrangements were applied to the government green bond program as well as the infrastructural bond program, to provide also greater flexibility to meet the needs of different investors of government bonds, to also make sure that other institutional investors will not be affected. The HKMA will not preset any allocation cap. It would depend on the investment decisions of the investment managers. And in our past experience, the existing mechanism already meets the needs of MPF investors for government bonds. We will continue to work with stakeholders to promote bond issuances and the development of the bond market. Thank you.
Next, Mr. Zhao Sichong. I'm an NMD of the MPFA. I support the government in enhancing the recovery process of default contributions and enhancing the regulatory regime. In fact, for default cases, things have become more serious in recent years. In 2024-25, the MPFA issued 400,000 demand notices to suspected non-compliant employers. In the end, only 21% of employers paid up within the time limit. In 2025, this figure dropped to 16%. Does it mean that many employers are cash-struck? Do they have financial hardship? In 2024-25, the outstanding amount stood at $191 million. But then, only $10 million remained outstanding afterwards. So the point is, the majority of employers failed to pay up not because of financial hardships. They just dragged on their feet when it comes to payment. So I support the second-tier surcharge mechanism. My question is this: how do you draw the line at the period of 120 days? The employers may default payment up to 119 days because the same rate of 5% surcharge applies. How do you make sure that the employees will pay up as quickly as possible? Why don't you put in place a progressive approach? And under the new arrangement, when it comes to prosecution, will there be any change in the prosecution policy, since you will impose a 10% surcharge at the lapse of 120 days? I will explain the background, then the MPFA representative can supplement. Now, we demand a 10% second-tier surcharge to be paid 120 days after the contribution date. And as explained in a previous discussion, if we adopt a floating rate mechanism or if we take a progressive approach, the formula will become very difficult to implement. It will become very complex. A two-tier mechanism is simple to understand and is very clear. We need to strike a balance between execution and cost management. The second-tier surcharge will provide incentive for employers to pay up as quickly as possible, so it will be more effective than the existing approach. As I mentioned in the outset, if there is a default, it's already against the law. On top of the surcharge, there are other tools available to take the employers to task, such as civil claims, criminal prosecution. On implementation details, I'll give the floor to the MPFA. Thank you for the question, Mr. Chow. For 120 days, how do we come by this figure? We have been overseeing MPF's operation for over 20 years. We understand the whole process. Say, when we demand payment of outstanding amount, the other side may file a counterclaim. So based on experience, we believe 120 days should suffice in going through all the steps, such as the claims and counterclaims. We want to make sure there is sufficient time to ascertain that the employer has no other reason not to pay up. The other point is about criminal prosecution. Now, be it 120 days or second-tier surcharge, when it comes to recidivists, we do not wait. We do not wait and impose the second-tier surcharge. Rather, we'll go to the court and file a claim or initiate prosecution right away. Next, Mr. Alan Chan. Thank you. In principle, I agree enhancing the recovery process of default MPF contributions, but I think that some fine-tuning is needed. The employers don't really feel the heat even with 120 days period in force, because we're talking about some law-abiding employers having a single fall from grace. They are not recidivists, and that the employers may need to take out a loan in order to pay up, and I don't think this will help much by allowing them a grace period of 120 days. We should follow the laws in the mainland, and that is for default in tax payment, they make 0.05% of the late payment fee. That's annualized 18.25% rate. It's much harsher than what we have in Hong Kong. We need to understand that SMEs are often trapped in the liquidity cycle. They are unable to make contributions as a result of overdue payment to them. So in the mainland, they have this very harsh approach of late payment fee of 0.05%. And yet, for MPFA, under circumstances, we can tweak the arrangement a bit and relax the rules, say, to consider whether the employer is a recidivist or whether the employer is trapped in a debt cycle. Many SMEs are not voluntary offenders. Now, please raise your questions. About preferential creditors, only if the debt holds up to over $50,000 will you be given priority. Otherwise, if it's just 50%, then it's not the preferential creditor. You should consider the bankruptcy laws as a whole, because if the employer then goes bankrupt, then there is no way you can reclaim the sum or recover the sum. Now, I will first give an answer and see if my colleagues would like to supplement. Under the current laws of Hong Kong, if an employer fails to make timely MPF contributions, basically this employer is in breach of our laws. There are different tools in the toolbox. We can initiate criminal prosecution. We can file a civil claim on behalf of the employee. We can also add a surcharge. Now, today's discussion focuses on surcharge. We want to impose a two-tier surcharge so as to increase incentive for the outstanding payment to be settled, and that we will be empowered to request for income information so that we can file a claim on behalf of the employee as quickly as possible. As for other suggestions and other supporting measures, of course, we'll heed members' views and consider them. Anything to add? Nothing to add. Next, Mr. Jonathan. Thank you, Chair. I agree with these enhancement measures. I think we need to step up deterrence. I support that. Now, I have a question on 9C of the MPF schemes regulation. Relaxation of requirements on the authority to invest and manage funds, and that non-SFC licensed entities can also provide professional knowledge. Now, but my concern is whether this will generate additional costs which will be transferred to the citizens. The second point is that the MPFA has responded that the responsibility lies with the supervising authority, and yet there will be increased compliance risks. Who will take this question, please? Now, thank you. To answer the member's question on 9C, the existing mechanism already covers the arrangement. We want to expand it in scope according to the current, according to experience. There are ways to handle this matter without additional risk. And of course, citizens are concerned about costs. We attach importance to the outcome, and that is the trustee and the managers will be responsible for their investment, and they will need to report the outcome. The portfolio contains different investment choices. In the end, we look at the return and whether the target is reached. And ultimately, it's for the manager and the trustees to be responsible. Ms. Cameron-Can. Thank you, Chair. I support the enhancement. That is the two-tier surcharge. According to the blog, as at the end of March in 2025-26 on average, every month, the MPFA issued 30,000 notices. That's roughly 370,000 per year. However, the notices do not mean that 370,000 employees have been affected. So I'd like to know the detail, if possible, exactly how many employees are affected. In about 120 days, can you explain how you have come by this figure and how does it compare to the tax default cases? Like the other members said, for malicious or intentional offenders that deliberately avoids paying MPF contributions, of course they should be subject to prosecution. Next, about relaxing the requirements to invest and manage funds. You've answered the question, but my concern is this. Say, if the employee has chosen a manager or a fund, and yet you allow the non-registered, non-SFC registered fund managers to take up the portfolio, then this doesn't mean the employee has picked that one. Can you explain that? Under Secretary, I'll give the floor to the MPFA in a moment. I would like to explain in 2025-26 the total number of notices issued was 375,200 notices, covering some 504,600 employees. So the member has made the correct point. I'll give the figures for your reference later. Mr. Chang, ED. About 120 days, I already explained that based on our practice and our operation and years of observation for the correspondence to go back and forth, objections, claims, counterclaims, so on and so forth, we believe we need 120 days. Now, to answer Ms. Cameron-Can's question on intentional offenders, for the two-tier surcharge targets one type of employers. These employers may not have financial hardship because they pay 5% surcharge for default on day one or default on 190 days, and we managed to done and recover all the sums. As for the second tier surcharge, these are recidivists, and we do not cause any more delay. We will go to the court and file a claim immediately for recidivists. Yes, Mr. Chang, to take the other question as well. About the resale practice, these will have to be disclosed in the document, and that disclosure should be made as to all the details before the alteration is made to inform investors.
主席俾我出席。
Last one to speak, Mr. Lam Wai Kwong. I would like to thank the chairman for letting me attend the discussion of this item as well as ask questions. MPF is very important because it involves the provision of long-term retirement protection for workers. It also relates to severance fees and long service payments offsetting. I hope that we can have a tiered system being an incentive for employers who can settle default contributions early on, because we're talking about accumulation here. The earlier they settle the contributions, the more in benefits it would generate for employees. Some members actually ask whether we will have additional tier or tiers for the two-tier surcharge system. Say for 3 months, one can charge 20% in surcharge, and more can even be charged for amounts remaining outstanding for longer. For employers who may be deliberately defaulting on contributions, how does the criminal prosecution process work? I think the questions have, well, at least the first question has been asked before. Perhaps the administration's representatives should just provide a brief response. Thank you, Chair. We do want to provide an incentive for employers with the two-tiered surcharge system to encourage employers to settle the contributions as soon as possible. We believe the two-tiered surcharge system to be appropriate because for those who are willing to pay, they have more than enough time to settle the contributions within 120 days. We will impose a 10% surcharge after 120 days. As for implementation, we do keep in mind different options, and we will continuously review the situation in future. Thank you. Mr. Cheng and Chi, please be brief. Thank you, Mr. Lam, for the comments. We have every year 200 to 300 summons issued. We have some who are convicted and we have some who are fined. We believe the process to be effective. Thank you. So that's the end of the discussion. I want to ask if members have any comments about the administration's plans to introduce the relevant amendments in Q4 of this year to Council. No comments. We support the proposals. Thank you, representatives from the administration and MPFA, for attending discussion of this item. Agenda item number 7, any other business? Is there any other business? If not, meeting adjourned. Thank you.